Sir, you are Michael Heil. We're here today for sentencing. Is there any legal reason why the defendant cannot be sentenced today, Mr. McCormick?
No, Your Honor.
Mr. Rosenwasser?
Judge, we remove the matter for sentence at this time.
I'll hear from the people first.
Thank you, Judge. As Your Honor is aware, back on September 21st, 2017, the defendant was found guilty after an approximately 4-week-long jury trial of each and every count under indictment 2016-561, that being murder in the second degree under 2 different theories, manslaughter in the first degree, as well as manslaughter in the second degree. And I'll tell you now at the outset that the people's recommendation is going to be maximum sentences with regard to each and every count. That is, with respect to count 1 and 2, 25 years to life in prison. With respect to count 3, 25 years determinate, plus 5 years of post-release supervision. And with respect to count 4, manslaughter in the second degree, 5 to 15 years in state prison. And upon information and belief, those sentences must be run concurrently. Before I make my remarks in support of the people's sentencing recommendation, with the court's permission, I would like an opportunity to read a victim impact statement, which was completed by Amber Wells, who is the victim Zachary Heil's mother. She was unable to be here today, but did request that I read this statement with the court's permission.
As you know, I'd ask you to read it slowly enough so that our court reporter can take it down. Sometimes we read more quickly than we speak.
Very well, Judge. And just so Your Honors know, this was a statement made by Ms. Wells to the Orange County Department of Probation.
Understood.
Ms. Wells stated that during her 17-year relationship with the defendant, he had been violent toward her and her children, and that he is a, quote, toxic person. She stated that both she and the defendant had grown up in foster care, and that over the years, the defendant refused to accept help to address his own mental health. Ms. Wells cites that while the defendant himself had suffered abuse as a child, he could have been different. He did not have to become the same person and kill his only son. Ms. Wells stated that if the defendant had taken responsibility for his son's death, it would alleviate some of her intense grief. She further stated that she is aware the defendant is attempting to place blame on her for Zachary's death, and this hurts her very deeply. Ms. Wells explained to this counselor that the defendant's actions have also greatly harmed his 2 young daughters, ages 4 and 5, who have since been placed in the custody of the Department of Social Services. She states that it is hard to believe the defendant ever loved her and their children. Ms. Wells stated to this counselor that she is the person who will someday have to explain to these children what their father has done and why their only brother is dead. She told this counselor of seeing the defendant's picture in the news, noting what she calls smirks on his face, and feeling so ashamed of him for what he has done. Ms. Wells stated at this time she continues to work hard to put her life back together, and her motivation to do so is due to her love for her 2 daughters and her deceased son, Zachary. She stated, quote, "My children are what is saving me." Her wish moving forward is that the defendant will, quote, hear, see, and feel what he has done, and he will someday care about his actions. Now, in considering my own remarks today in support of the people's application for maximum sentences with respect to each and every count, I did not have much difficulty coming up with reasons in support of the same. On the contrary, I couldn't come up with a single reason why the defendant should not receive the maximum penalty as prescribed by law. And I would suggest to the court that the court need not look any farther than the facts of the case on their face. There can be no more of a heinous crime against a more vulnerable victim than a father taking the life of his own child at the tender age of 7 weeks old. A victim that couldn't fight, couldn't run, in this case couldn't even roll over. I would submit to you, if you took that fact alone and you went out in public and you interviewed 10 people on the street and you told them a father was found guilty beyond a reasonable doubt by a jury of his peers of violently killing his own son, only 7 weeks old. And you ask them, do you think 25 years to life is appropriate? I would submit to the court that all 10 would say, is that all he can get? He can't get any more? And the reason is because that this crime is so unimaginable that it shocks the conscience. It's so contrary to what parents do with respect to their children. They give life, not take it. There's no one that would come to a different conclusion than that, no right-minded person. And in order for this court to fashion an appropriate sentence, the court must consider what conduct did the defendant actually do which caused Zachary's death? How violent of an ending did Zachary suffer at the hands of his own father? What could he have done to cause such massive bleeding in Zachary's brain to require surgery and lead to his death, to require such massive blood loss in his eyes, so much so that his retina was actually detached and pulled away, covered in bruises? The experts, the people's experts that testified in this case, used words like, I've seen it in textbooks, I've read it in the literature, but I've never actually seen it. This wasn't a close call for those medical professionals that were involved. This was textbook child abuse. Well, the defendant never told us what he did, and nobody in this courtroom was there, but I think the court can infer logically, based upon the evidence, exactly what happened. The court is aware of the day the defendant had that day, a building of frustration, a pattern of anger. You can determine, based upon the pattern bruising located on Zachary, that he was grabbed, likely by the lower half of his body, and as the experts told you, repeatedly slammed, shaken, thrown. These were horrific injuries that required a great amount of force, and I would submit to the court repetition. Now, throughout this trial and in my jury selection, I spoke to the jury at length about the fact that the defendant did not wake up on August 7th that day and make a conscious decision to murder his own son, but I submit to the court he should be treated exactly as if he did. It doesn't surprise me that when the defendant was interviewed by the police, he denied committing the crimes as charged. It doesn't surprise me that when he testified in this trial, he denied committing the crimes charged. He pled not guilty, he asked for a trial. It doesn't surprise me that he denied the crimes as charged to the probation department. But what does surprise me, and what I find most shocking, is that in the moments after the defendant did what he did, which caused Zachary's death, in that moment, when he realized what he did and he looked down, in his words, at Zachary's lifeless body, his first instinct was not to attempt to save Zachary, but one of self-preservation. Your Honor heard of what transpired in those immediate moments after Zachary became lifeless, in the defendant's words. You heard how the first call was not to 911. It was to the defendant's sister, someone I'd submit to he thought could help him, someone he trusted, probably the only person he trusted, that he thought could get him out of this. She couldn't help him. Then he waited for 1 minute and 1/2 before he called 911. And when he finally did call 911, with the phone in his hand for that whole 1.5 minutes after he spoke to his sister, he didn't tell them honestly what happened. He didn't tell them on the 911 call what happened, and he didn't tell the EMTs when they arrived what happened. There was a term used by a neurosurgeon in this case. Time is brain. Those moments after Zachary became lifeless, we'll never know if the defendant had been truthful about what happened. One thing is for sure, he would have been airlifted directly to Westchester. That would have made a difference of 8 or 9 hours in terms of getting him into surgery. It could have given him a chance. And as parents, we can say, well, you could get frustrated with a child, maybe he lost his mind, maybe he was overcome with emotion. But in that moment, after he realized what he had done, when he looked down at his dying son, even in that moment, he could have given this court something to mitigate against the maximum sentence. In that moment, he could have done the right thing and given his son a chance to live. And he didn't. And had he, perhaps that would have provided the court some mitigation. But it's shocking and it's appalling that he didn't. And not only did he not do that, he didn't even go to the hospital when Zachary was there. And because he didn't tell what happened to the first responders, Zachary suffered for 14 days before he finally died, hooked up to breathing tubes and being kept alive by machines. He made that choice after he was overcome. Now, I'm sure the defendant's sitting there thinking about his own life and the sentence that the court is about to impose, but I'd submit to you that the defendant's life is not the only life that was ruined in this case. He ruined and ended his son's life. And instead of his son being able to make his own way in this world, to leave his own legacy, the defendant's going to leave it for him. Zachary Heil's legacy is going to be as a victim in a murder prosecution of his father. It's going to be a name in a transcript from today until forever. He's not going to be remembered for his accomplishments on an athletic field. He's not going to be remembered for his academic accomplishments. The defendant never gave him that choice. He robbed him of that. Because of his choices, Zachary's legacy will be left in a transcript as a victim of murder. He ruined the life of his sister and brother, who had to come in here and testify against him, and who are reminded of the horror of this event every single day because it happened in their living room after they graciously allowed the defendant and his family to reside there. They looked at the place where this happened each and every day. He ruined the life of his other two young children who were present and who witnessed this. The damage done to them, we don't know today, and we may never know the extent of that damage. And he ruined the life of Amber Wells by taking away her only son. Now, in fashioning a sentence, the court must also consider the background of the defendant. Well, I submit to you, Judge, there is nothing redeeming there. The defendant has several misdemeanor convictions, all related to, guess what? Violence against his family. Assaulting his pregnant wife, violating orders of protection in front of his one month-old, I think, actually at the time, child. This is not a person who gets angry and acts out at strangers. This is someone who gets angry and acts out at his own family. There are no redeeming qualities with regard to his background. This is not a person that deserves a break. This is not a person that deserves 1 day less than the maximum punishment as allowable by law. The court must also consider the conduct which the jury found the defendant engaged in. Depraved indifference. And Your Honor is well aware of these terms, but depraved indifference to human life reflects a wicked, evil, or inhuman state of mind as manifested by brutal, heinous, and despicable acts. It is evinced by conduct that is wanton, deficient in a moral sense of concern, devoid of regard for the life or lives of others, and so blameworthy as to justify the same criminal liability that the law imposes on a person who intentionally kills. That type of conduct directed towards a 7-week-old child can only and must only be met with the maximum punishment allowable by law. And because of that, the people would ask that the court impose the sentence as previously outlined, that being 25 years to life with respect to count 1 and 2, 25 years plus 5 years of post-release supervision with regard to count 3, and 5 to 15 years in state prison with regard to count 4. Thank you, Your Honor.
Thank you. Mr. McCormick?
Yes, Your Honor. My client, Michael Heil, from the date of his arrest and the inception of the charges, the indictment in this matter, had maintained his innocence. He exercised his right to go to trial, was convicted upon trial. And as he stands here today, he maintains is innocent. Any remarks that I could make further would lend themselves or tend to lend themselves to relitigating these issues at trial. Something that would be neither appropriate nor germane to the proceeding today. So that's the only remarks that I can state for the record on behalf of Michael.
Thank you. Mr. Heil, the law affords you an opportunity to be heard before and post-sentence. You're not required to say anything, but if you do want to say something, now would be the time to say it.
Just stand behind what I said during my testimony. Mr. Rosenwasser alluded that I'm worried about only my own life being ruined. That's not the case. I know I've been neglecting to give Zachary the medical attention that he should have gotten tonight, as well as screaming at me. I take responsibility for that alone. I stand behind what I said. I'm not the one who caused these injuries, but I am the one that neglected to get him the proper medical attention.
Well, as Mr. Rosenwasser indicated, there is no allegation of any intentional act here. There is no allegation that you set out that day to kill your son. And even after the jury has rejected this claim, based upon the medical evidence and based upon what seems like an extraordinarily preposterous claim you make in terms of how Zachary could have sustained these massive traumatic brain injuries, you continue, as is your right, you continue to maintain your innocence and indicate you had nothing to do with it, despite what this court believes is the overwhelming evidence of your guilt. I think both Ms. Wells' statement and Mr. Rosenwasser's statements touch upon the things that I would say. The only thing that I would add to that is that your continued denial, coupled with your consistent unwillingness or inability to accept responsibility for your actions, as well as your attempts to place blame on someone else, that being Zachary's mother, make it clear to me that there is no mitigation in this case. It make it clear to me that it's not likely that you're thinking about anyone other than yourself in connection with this case. And so, as Mr. Rosenwasser said, and some people may have an issue with respect to, and there's been literature on whether or not a depraved indifference conviction should be treated the same as an intentional murder, a premeditated intentional murder. And I would just point out one thing. While I can appreciate Mr. Rosenwasser's statement with respect to polling of citizens in our community, that's not what this court can be concerned with. What this court has to be concerned with is what is the appropriate sentence for you under the facts and circumstances of this case. And I find, as the jury likely did, that your conduct was so deficient in a moral sense of concern, and that your acts in terms of the injuries that were sustained by your 7-week-old son were so despicable in terms of how they must have been rendered on him, that there is no sentence which would be appropriate other than the maximum sentence. So for your conviction for the first count, murder in the second degree, you are sentenced to an indeterminate period of incarceration, the minimum which will be 25 years, the maximum which will be life. For your conviction of the second count of murder in the second degree, your sentence will be an indeterminate period of incarceration, the minimum which will be 25 years, the maximum which will be life. For your conviction for the third count, manslaughter in the first degree, your sentence will be a determinate period of incarceration. That will be 25 years with 5 years of post-release supervision. And for your conviction for manslaughter in the second degree, your sentence will be an indeterminate period of incarceration, the minimum which will be 5 years, the maximum which will be 15 years. Those sentences, as a matter of law, must run concurrent to each other, and as such, they will run concurrent to each other. There's also a $300 surcharge a $50 DNA databank fee and a $25 crime victim assistance fee that'll be assessed and mandatory fines. They're really of little import given the gravity of this case and the gravity of your actions. I hope at some point in the future you can come to terms with what you did. But at this point, your continued denial leaves me without any mitigation in connection with the sentencing on this case. The aforesaid does constitute the judgment and sentence of this court. Please read his right to appeal.
You have a right to appeal to the Appellate Division, Second Department within 30 days, and in addition upon proof of your financial inability to retain counsel and to pay the cost and expenses of the appeal, you have a right to apply to the Appellate Division, Second Department for assignment of counsel and for leave to prosecute the appeal as a court person and to the expense of the plaintiff. The Appellate Division, Second Department is located at 45 Monroe Street, Brooklyn, New York, 11201.
Proceedings are complete. Five-minute break.